Hello, my name is Robert Sterne and I am a founding director of the intellectual property specialty firm of Sterne, Kessler, Goldstein Fox in Washington, D.C. I'm also editor-in-chief of Patent Office Litigation, the first and most definitive book published on the new contested proceedings at the United States Patent and Trademark Office. These new contested proceedings and the new supplemental examination that I will be addressing today became operational on September 16, 2012. Today it is June of 2013, and I want to talk to you about the issue that has recently arisen at the Patent Trial and Appeal Board, and that is the issue of the interplay between the new supplemental examination and the new inter-party reviews. So a little bit of background. Supplemental examination is a new proceeding that the patent owner only can bring at the USPTO before suit is filed. It is used to address issues involving patentability of claims of issued patents. In particular, it is crafted to be used to address possible issues of inequitable conduct. However, any possible defense under Section 282 of the patent law can be addressed in these new contested proceedings. The Central Re-Examination Unit at the USPTO is tasked with the responsibility of handling these new supplemental examinations. To date, not many have been filed, and there are many reasons why this may be the case. But for now, I just want to address the interplay between the new supplemental proceedings that can be filed by the patent owner involving its own patent and an inter-party review that can be filed only by a challenger against the same patent and the same patent claims at the new Patent Trial and Appeal Board created on September 16, 2012. So let's take a look at what is actually happening. In IPR 2013-00122, the patent owner, Merchandising Technologies, filed a supplemental examination on October 31, 2012. Now, the petitioner, Invu Security Products, filed an inter-parties review petition on January 24, 2013, and filed a motion for stay of the supplemental examination. The board originally dismissed as moot the motion to stay the supplemental examination as being untimely, but then stayed the ex parte re-examination resulting from the supplemental examination at the CRU. This IPR presents a very interesting scenario. Very few supplemental examinations, as I have said, have been filed by patent owners. What may have happened here that drove one is that the patent owner was presented with some prior art that may have raised the specter of inequitable conduct. The patent owner may then have filed a supplemental examination to cure this issue before suit, since no suit had been filed. After the supplemental examination was filed, the challenger then filed the IPR so as to create a contested proceeding instead of a patent owner single-sided ex parte re-examination at the CRU. This is the supplemental examination approach that may be the wave of the future, where a patent owner in licensing, where no suit has been filed, is presented with prior art by a potential licensee during negotiations. Now, we are reviewing at the Sterne-Kessler Contested Proceedings Working Group all of the decisions from the Patent and Trial and Appeal Board. And they show that many major attorneys in major firms are making major mistakes in these new contested proceedings. And many of these major mistakes, unfortunately, are fatal. I want to point out that the new contested proceedings, particularly the IPRs, appear much more middle of the road for the patent owner than the prior inter-party re-examinations. They take away from the patent owner many of the rights. But what people need to understand is that regardless of what side of the proceedings you are on, you should not dabble in these new contested proceedings. You have to be very diligent and very careful, regardless of your experience level. These new contested proceedings are unforgiving, and many times one can lose them for reasons that have nothing to do with the merits. We will continue to keep you posted on developments at the board. I thank you very much for your time. Good day.